Good afternoon, everybody. Welcome to the League of California Cities webinar. This webinar is entitled Updated CalPERS Industrial Disability Retirement Regulations that Human Resources Professionals Need to Know. Thank you for joining us this afternoon. My name is Leanne McPhillips. I'm from the city of Gilroy, and I'm helping to moderate today's session. Next slide. So there's a few housekeeping things that we want to let all the participants who are here today know about. This session is being recorded, and all of the attendees have been muted. We do have the question and answer feature available throughout the webinar, and our presenter is encouraging questions as we're going along. And as long as there's enough time to get to the questions during the webinar, we will do so. Otherwise, we will push questions to the end of the session. To write in a question, select the Q&A button on your toolbar, and then following the presentation, the recording and the slides will also be shared with the attendees. So if you miss any part of today, you'll be able to rewatch that with the recording. If you haven't done so, please consider attending the annual League of California Cities Conference and Expo that is coming up in September 20th to 22nd in Sacramento, California. It's a great conference with sessions on a variety of different topics, and you're sure to get a lot out of it if you choose to attend. We want to talk to you a little bit about how you can get involved with the Personnel and Employee Relations Department of the League of Cities. The first way you can get involved is subscribing to the listserv. And you'll see on the next screen here when it goes forward. Here you go. So if you go to the League of Cities page and click on the Get Involved button at the top of the bar, and then once you get there, look for the Personnel and Employee Relations Department page. And once you select that, you can then move over to the page where you can see various activities and things happening with the League of California Cities Personnel and Employee Relations Department. When you're subscribing to the listserv, enter your email, your name, your city, your password, and the spaces that are provided. And then you can also use this page to view past archives or to edit or remove your subscription. We do need to advance one slide. And then you can send posts to the listserv, and people can answer questions that you may have. You can respond to questions that other people have. And it's really a great way to share information with your human resources peers. Moving forward. And then we also have monthly department meetings. These are very valuable meetings to interact real time with other HR professionals. We meet on the first Tuesday of each month at 3 o'clock via Zoom, and you can see the schedule of the upcoming meetings on the screen. We get legislative updates, hear about different announcements from our department officers, and then we typically have a roundtable and a question and answer period. If you're interested in participating in these monthly meetings, you can reach out to Megan McKelvey or Isaac Black, both with Cal Cities, and their emails are up on the screen. Let them know that you want to participate, and they will add you to the meeting invite and send you the Zoom link. Next, I am happy to introduce our speaker for today, Michael Yorl, who's an attorney with the Liebert Cassidy Whitmore Public Employment Law Firm. So this is an extra special treat that he's here with us today. He has a variety of experience assisting public sector clients on a variety of different matters, but he has particular expertise in post-retirement work restrictions, independent contractor status, disability retirement, hence today's presentation, PEPRA compliance, and CalPERS PEMCA medical. So he is available to provide advice and counsel to public sector employers. And we are so happy that you were willing to provide us with this presentation today, Michael. We're looking forward to hearing from you. Thank you very much. Enjoy the webinar.
All right, good afternoon, everybody. Thanks for joining. Thanks, Leanne, for the introduction and the intro. As you mentioned, my name is Michael Earl. I'm an attorney with Liebert Cassidy Whitmore in our Fresno office. If any of you have had CalPERS issues, you may have talked to me. You may have seen me present on other CalPERS issues. I spend about half my life arguing with CalPERS or dealing with CalPERS issues, so of course, very fulfilling. A couple of housekeeping rules. So as you mentioned, as you put questions up into the box, I'll generally take them as I go. But if we've got, maybe a bunch coming on, I might defer them. Or if there's a little bit of a slide coming a little bit later that might answer it, I might defer it. But I'll usually take them as I go. Other housekeeping item, if you've seen me present before, you know that I'm a notorious fast talker. I moonlight as the person who does the side effect disclosures at the end of a drug commercial. So if you have questions, again, just put them in the box. But I'll try to slow down and highlight points as we go through. So with that, we can kind of just jump right into it. So we're going to be talking about the updated CalPERS IDR requirements that HR professionals need to know. Technically, they're going to be requirements. CalPERS didn't actually proceed through the formal regulation process, so we don't mean it in regulations in that sense. This was mostly done by kind of administrative guidance, circular letter, and there's some kind of additional informalities going on in the background that we'll talk about. So here's our agenda for the day, just generally. So we're going to talk about some background information on disability retirement. So just kind of the nuts and bolts pieces of it. If you do a lot of these, you may already be kind of familiar with these. So I'll move through them kind of quickly. We're going to talk about CalPERS previous certification requirements by the governing body and the delegate if applicable. These requirements still pretty much stay in place because we're still using the same certification forms that we were, and they still ask for and require the same information that they did before. But we've got a bunch of new stuff too that we're having to comply with. So we'll kind of explain what the process was before, which was really, we just kind of sent in the certification letter and that was kind of the end of it. Now we have to provide a lot of the backup information and background information to go along with it. Then we're going to talk about the new requirements, so the additional information that's going to be required. I'll also talk about some important reminders for granting and denying IDRs, and I'll talk about some of the distinctions. So there are a lot of the IDR process kind of moves along a parallel track with workers' comp, but it is different. There's a lot of things that are different. We don't really necessarily need a permanent stationary finding. The workers' comp uses work restrictions that CalPERS and the Public Employees Retirement Law, like prophylactic restrictions that we don't follow. There's other interesting things like there's presumptions under workers' comp, and those don't technically apply under the Public Employees Retirement Law. So we'll go over some of those kind of as we go through as well, as well as some of the mechanics for granting IDRs. So generally, Government Code Section 21154, which is part of the Public Employees Retirement Law, provides that the local governing body makes the decision on a CalPERS disability retirement for local safety. Now, that's the default. So the default is that the decision sits with the governing body. But most agencies, and if I was going to ask you about it or poll the audience, I would suspect that most of you have done this delegation of authority. So for example, for cities, most cities have delegated the decision-making on a disability retirement for local safety to the city manager, for example, is the most common, but so that those decisions aren't really going to the governing body anymore. And I think that kind of makes sense. It really simplifies the process. It's also kind of touchy because of all the medical information that's involved in these decisions. So along with all the open meeting laws and things like that, it's a little sometimes difficult to kind of balance that when you're having the governing body make the decision. So most agencies have delegated this decision, and it's pretty simple. You just file a resolution delegating the decision to an agent. And then when you send in your CalPERS certifications, you need to attach that delegation resolution so that CalPERS knows that there's that authority has been delegated to the individual. So again, just some of the background basics of disability retirement. So we have non-industrial disability retirements. That just means that the cause of disability need not be related to employment. So it could be that someone was involved in an off-duty car accident. They can no longer perform the duties or the essential functions of their position because of that car accident. And if that's the case, they might be entitled to a disability retirement, but not an industrial disability retirement. So a lot of the ones we're dealing with for safety are going to be industrial disability retirements. And in those cases, the disability is due to a job-related injury or illness. And case law and statutes have defined this as being the industrial connection must be real and measurable, is what we use in CalPERS land. Generally, industrial disabilities retirements are only going to apply to safety employees. So even for your miscellaneous, for the most part, if they are involved in even a work-related injury or accident or something like that, they still only qualify for disability retirement because they don't have eligibility for an industrial disability retirement. Now, there's a note, and it's going to a small caveat that'll be on a later slide. It's generally only for safety. There is an optional CalPERS provision to extend it to miscellaneous, but there's only a handful of agencies that have that. It's extremely rare. All right, so as far as who is eligible for a CalPERS disability retirement, for non-industrial disability retirement, there is a vesting requirement. So if there's no industrial causation, or if we're dealing with a miscellaneous employee for the most part, they have to have 5 years of service. And so if they don't have 5 years of service, then they're not eligible for a non-industrial or just a regular disability retirement. There is no age requirement, and the individual has to be substantially incapacitated from the performance of their usual and customary duties as a result of a non-industrial or for miscellaneous industrial injury. Now, this is important too for any of you that do things like leave management, or where we're separating employees for inability to reasonably accommodate. Because under Government Code Section 21153, if an employee is eligible for a disability retirement, then you're not supposed to separate them due to disability. You're supposed to apply for a disability retirement on their behalf. So if you're in charge of doing the interactive process and trying to look at whether someone needs to be separated because of your inability to accommodate them, one of the questions you always need to ask yourself when you're going through that process is, does this person have 5 years or more of service credit? Because if the answer is yes, it really means that we need to apply for disability retirement on their behalf. You can't just separate them. Somebody asked, is the 5 years of service with the agency they're filing a disability retirement with, or 5 years credit overall? It's 5 years credited with CalPERS. So you do have to check and see if they are, so they may have only been with you for 2 or 3 years, but they may have additional service credit with another employer. And so that's a good question. You do have to check what their service credit is. Usually you can pull that in My CalPERS. All right. So moving on to an industrial, CalPERS industrial injury disability retirement. So an industrial disability retirement. Same thing with substantially incapacitated from service as a result of industrial injury. There is no age requirement. And for an industrial disability retirement, there is no service credit requirement. So the person could be, brand new, and they would still qualify for an industrial disability retirement if they otherwise met the requirements. It applies to safety members by law. So most of your fire and police are going to fall under this. As I mentioned, it's mostly safety, but there is an optional provision to extend it to miscellaneous, but it's extremely rare. Sorry. So for the definition of, I jumped the slide. The definition of a disability under the PEARL is incapacitation of performance of duty. And typically what that means is permanent or extended and uncertain duration, which is expected to last 12 consecutive months or result in death. So previously, before it was amended a few years ago, the statute just said that it had to be either permanent or of extended and uncertain duration. And CalPERS had just kind of informally through guidance had interpreted that as meaning 6 months or more. But later they went through a process, so they put out some guidance, and then later the statute was amended to clarify that basically extended means expected to last 12 consecutive months or will result in death or is permanent. If you look at their circular letters, and we'll talk about this a little bit later, you'll notice that it actually uses a little bit different language in the circular letters. It talks about 12 months from the date of the application. That's what the circular letter says. The statute just says 12 consecutive months. It doesn't actually specify from the date of the application. And there's going to be a couple things like that where we'll talk about what the statute says versus how CalPERS is kind of administratively interpreting it. And it has to be based on competent medical opinion, and this is another area that we'll talk about. So competent medical opinion is in the statute. It doesn't have a specific definition, But recently, and I don't know if any of you, some of you may have attended CalPERS webinar or have had back and forth with CalPERS about issues with competent medical evidence. This is one of the things I'm seeing, and I'll kind of point that out as I go through some of the things I'm seeing coming out of the unit with cities, districts, et cetera, is that they have kind of internally defined it as requiring it to be the medical opinion to be done by a specialist in the individual's condition. That's not in the statute. I'm not aware of it in any kind of administrative guidance, other than the fact that specialist shows up on their local agency disability form that we'll talk about. I have also seen them take the position, and I believe they said this in their webinar, that it has to be a MD. So for example, a lot of employees will, on a psychological condition, do treat with a PhD who is board certified in psychology. But I've seen CalPERS has not accepted those in some cases. I'm not really sure where they are on the formal process, but I've seen them kick some of those back, taking the position that they are insufficient. Prior to this, I believe I wasn't aware that they were had applied that interpretation. So talking about the information that CalPERS previously required, and although we're saying they previously required this, this is still part of the certification process. But this used to be pretty much the whole certification process. We would just send a kind of a form certification informing them of our decision, and that was kind of it. Now we're going to see as we go forward, they're requiring a bunch of additional background information. So previously, just kind of generally going through this, we had to provide a statement certifying under penalty of perjury that the decision is based on competent medical opinion, a statement certifying under penalty of perjury that the agency did not use the determination as a substitute for the disciplinary process. And there's a couple different times you have to certify this. So you have to certify it usually as part of the, the employer application, or when you fill out the employer portion for the employee, and then we have to certify it again in the certification resolution. And I'll kind of point out that this is one of the areas where it was kind of like a Wild West, in that we didn't have a very good process for flagging these issues to CalPERS, and CalPERS didn't really have a process for dealing with them. There was also a lot of misconceptions on the law. So, the individual would file the application, and CalPERS would ask the agency to make a decision, but there was never a specific inquiry into whether there was discipline in play. You also had situations where under case law, it's not the date of the injury that determines whether or not they're eligible for an industrial disability retirement. When we talk about whether there's discipline in play, it's actually the date of when the retirement, the entitlement to the disability retirement matures, which means they have basically a right to start receiving the disability retirement allowance. Or there's also an equitable potential where if it was pretty much guaranteed that they were going to get it based on the status they were in, that might apply. But what we kind of had seen is there would be situations where someone would engage in misconduct, and they would either try to file an industrial disability retirement application and try to retire before they were terminated, or they would start working up an old injury. So maybe they had an open workers' comp claim, and they would state that based on that previous injury, they were incapacitated. And there wasn't really a process for flagging that. So now CalPERS has the process for flagging it. They ask you if you tell them that there is discipline pending. For example, the individual has been terminated, they're undergoing an IA, something like that is happening. We're supposed to notify CalPERS, and CalPERS will basically holds the application and figures out whether they're eligible. If CalPERS determines they are not eligible, then CalPERS gives them their appeal rights, and the individual can appeal the decision essentially that they're not eligible. And so I think that's one of the areas where we saw CalPERS kind of have a process that they didn't really have a process, and they kind of firmed it up. And I'm hoping that's what we're going to see with some of this retirement, their new requirements as we move forward. A finding indicating that the member's substantial incapacitation from the performance of their usual duties. So is the individual incapacitated? A statement of whether there was a filed workers' comp claim, and if so, whether it was accepted. A finding by the agency as to whether the member's incapacity is industrial. A statement regarding the individual's last day on payroll, so the last day they received wages from us. a statement as to whether there is the possibility of third-party liability. And the reason CalPERS asks that is because if the individual or some other individual could be sued for the wrongdoing, then CalPERS might have a right of subrogation to recover some of the money that was paid out from that party. So for example, there's been instances where an individual was hurt in an on-duty incident, and they sued the individual civilly, and CalPERS will file basically kind of a lien in case there's a civil recovery so that they get an offset. It's not that common because a lot of these times they would be individuals who are either it's in the course of their employment and there's nobody at fault, or if the person is at fault, frankly, it's going to be maybe a criminal act where the individual is going to be judgment proof and you're not really going to see any kind of lawsuit. A statement identifying the disability conditions or the body part. So we basically will say, low back, lumbar spine, knee, something along those lines. What is the injured body part? A statement that the decision is supported by competent medical evidence, that the disability is going to last at least 12 months, result in death, or will be permanent. And finally, a statement regarding the advanced disability pension payments that an individual will be paid if we're going to pay advanced disability pension payments. So if you know you're going to, so if you're granting the IDR, we have an obligation to basically advance the disability pension payments. And so you take the 50% over the last 3 years, and we put that amount into the certification, and that lets CalPERS know how much to pay us back, because advanced disability pension payments are going to be reimbursed to the agency if the individual gets it. Now, if the disability retirement is ultimately denied, then the statute says that we can recover that money, but we basically have to go through the process, meaning the individual has to agree to a repayment plan, or we have to have some kind of civil action or lawsuit to try to recover that money if they don't. Somebody asked, why is information still required on this resolution if they are all stated on the news CalPERS IDR forms? So we do have to provide a lot of this information on the IDR forms. I don't know if this is kind of a vestige or if they like having the actual whole document and then it's being certified by somebody. It says that it's being certified under penalty of perjury, but they have, for whatever reason, kept the requirement to provide a certification. Just as a practice point, I also usually provide individuals, the actual member, a letter notifying them of the agency's decision and providing them their appeal rights. Because when it comes to disability retirements, if we deny it and the individual wants to appeal, with respect to the incapacity component, that goes to the Office of Administrative Hearings. We actually have to set up the hearings and drive the bus on that one. So, the agency has to retain OAH generally. They have to put on the case. And so it's going to be the agency that has to take that laboring oar. Somebody said, ADPP, CalPERS continues to provide emails that indicate that the employer should not start advancing advanced disability pension payments until CalPERS tells us to. This seems opposite of the concept obligation. I would agree with that. I have seen some determinations where they told us not to pay it. There are circumstances where I think it makes sense that we don't pay it. One is if they're service retiring, but the requirement to pay advanced disability pension payment is actually in the labor code, and it is pretty clear when they're supposed to start. And it also provides the exceptions for when it does not apply. Now, I will say that there are times where you might think it applies and it doesn't based on the statute. So the time for when advanced disability pension payments begins is tied a lot of times to the leave. So it has to start within 30 days of the last time they received essentially paid leave compensation. So that's usually gonna be 4850 or sick leave. And they usually have a right to run out 4850 and sick leave before their disability retirement becomes effective. However, there was some ambiguity in the statute because it does say that the member has to file the application at least, I think it's 60 days prior to their effective retirement date. And so in some of these cases where the individual is trying to get the employer to file the application, then there's an argument, it always looked like there was an argument that advanced disability pension payments didn't have to start because we filed the application, they didn't. And CalPERS seems to kind of agree with that because their position is they can't really calculate it until they know the individual is what their withholdings are going to be, or what their options are going to be rather, and whether they're actually going to proceed with pursuing the disability retirement or if they're going to essentially not respond. So another kind of practice point is you will see a number of employees or workers' comp attorneys, applicants' attorneys will want the agency to file the application for the employee, and they will be insistent on it. They will drag their feet. They'll tell you it's your obligation to apply. And I think, even if we apply, we can still deny the application based on the review of the medical evidence. So I think a lot of that is basically a misconception that CalPERS is making the actual substantive decision, and that if we apply on their behalf, then there's a better chance that this is going to go through. But that's not true. What really happens is that when we file the employer-originated application on their behalf, it basically just generates a letter to the employee saying the employer's filed an application on your behalf. You have to respond and file an application by X date, or we'll cancel your application. And I think they do a warning letter or something like that. But really, all it does when the employer files is create an extra step. But I have seen that where a lot of either employees or applicants' attorneys are just adamant that that they want the IDR and they want it to be applied. They want someone to apply for it, but they want the agency to be the one to do it. And in reality, it just creates another step, but it's sometimes impossible to convey that. So somebody asked, for a safety member, can we put a future date or term, say November 1st, so that the employee can use a bit of sick leave while we are processing all of the paperwork, given it will take PERS a few months rather than pay ADPP? So technically, you can have a future retirement date, and that can happen for a couple of reasons. So under Government Code Section 21163 and 21164, employees have a right to run out their 4850 leave with some minor exceptions, and employees have a right to run out their sick leave before the disability retirement becomes effective. So that can even mean that it's basically we all agree that there's going to be a disability retirement in this case, but the employee can actually run out their sick leave before it actually becomes effective. And so in some of those, we'll actually have to project out the date and determine when it's going to be. And I believe I've never had CalPERS kick that before because it's a future date. So that will happen where you have a date in the future, or where you're waiting on something because the employee wants to run out their leave before the disability retirement becomes effective. Somebody asked, will you please give examples of when advanced disability pension payments are required? So it's under Labor Code 4850 and I think 4850.3, 4850.4. And so it sets forth the criteria, but generally, if the individual is qualified for 4850 benefits, and they've applied for the disability retirement, so generally I think 60 days, they're supposed to apply within 60 days of their desired effective retirement date, and they have run out of their 4850 and sick leave. So basically we've moved them into an unpaid status. We have to start 30 days after that, after they've run out their leave. It has to start within 30 days. And there's also a couple other carve outs where you don't have to pay ADPP. So for example, one of them is if the employee refuses to attend required statutory medical examinations. There's some where it's determined that it's not industrial, but it has to be clear. And there's a couple of other criteria where you don't have to pay ADPP. But in normal circumstances where they were qualified for 4850, they've applied for disability retirement, you're generally going to have ADPP obligations. However, be careful, because if somebody's service retires pending, CalPERS takes the position that there's no ADPP owed and they won't reimburse it, and that's between you and the employee. So somebody indicated that you can't have a future retirement date of more than 120 days, or that CalPERS indicated that you can't have a future date of more than 120 days. They might have said that on their webinar. I'm not sure if that actually comes from a statute. Usually we don't run them that far out. But thanks for letting us know. So someone asked, we have a safety employee who filed a service retirement pending IDR. They're waiting on appointments. Does the 6-month rule for responding still apply? Yes. So what they're referring to is there is a 6-month. So by statute, when an employee files a disability retirement application, CalPERS will generate the letter to you telling you that by statute, you have 6 months to make the determination on the individual's application. However, the employee can waive the 6-month requirement and let you go beyond it. CalPERS has adopted an internal rule of which I'm not aware being written anywhere, but I know it's their position that they will only allow one 6-month extension. So they will have a maximum pending period of a year. and then they will cancel the application, is my understanding, which is kind of strange because that's actually the employer's failure, not the employee's failure. So I don't know why that would result in a cancellation of the employee's application, but that's what I've been told and have seen as the process. So if you are at the 6-month mark, or if you get to your mark and you don't have enough medical, what I usually do is say, we'll reach out to the employee and let them know, hey, we're still developing medical here. We'd like to get an extension of this deadline so that we can, have enough medical evidence to make a decision. The other thing you can do is you can send the employee to an independent medical exam, which I will be talking about as we go through the slides, and get basically a medical opinion of your own. Does this person meet the standard or not? And the third option is technically the employee has the burden of proof. So if they don't have enough medical evidence to substantiate their IDR, then you could deny it. And then they would have to appeal it and go through that whole process. So a lot of times it's in their best interest. Like if the medical really is not developed, then it's in their best interest to give you the extension. The other area where this comes up, and I'm going to talk about some of the issues that are coming with this a little bit later, is sometimes all we'll have at this stage is the PTP, the primary treating physician. And as far as medical goes, that is the lowest on the totem pole. And some of you do this a lot, might see that employees switch their PTPs, or sometimes they get released back to work and then they switch PTPs, or they get an attorney who switches them. And all of a sudden everything it's night and day from what it was before. And so that, I'm not, trying to bash on PTPs or anything like that, but that tends to be the medical that's the most, kind of closest to the employee's, desired outcome. Okay. Take a couple, then I gotta try to move on. What if the employer files for IDR when the employee still has 4850 left? Our move has been to terminate 4850 and begin ADPP. So that is kind of a question that I've seen go back and forth with workers' comp. The statutes on 4850 and the public employees retirement law on when the disability retirement begins under Government Code Section 21164 are kind of in conflict, because if you look at 21164, it says that they get 4850, or that their retirement application or their retirement allowance rather can't be effective until they've exhausted their 4850 or they've been found permanent and stationary by the Workers' Compensation Appeals Board. Now, we don't really have those kind of findings from the WCAB, since most of them are done by CNR or something along those lines, and all we get is a doctor saying the person is permanent and stationary, or MMI now more commonly. And so there's this question about, does that actually cut it off? And then to make things more confusing, under the labor code sections that are applicable to ADPP, it actually says that you can end 4850 when they started getting the retirement allowance. And so you end up with their permanent stationary and started getting the retirement allowance. You kind of end up with this circular problem between the two different statutes. And I've seen some workers' comp attorneys take the position that you cut it off, but I think the prevailing view is you don't. Somebody asked about with remaining 4850, could you discuss buyout? So I guess probably what you're asking is, there are some times where we have a dispute about how much 4850 is owed or something like that, and we will essentially agree to pay a certain amount to cover the 4850 period, but that's usually done as part of a negotiation on the workers' comp side. If an employee another question, if a former employee applied for a disability retirement and is now qualified for an industrial disability retirement, but signed a CNR for his workers' comp claim, do they have to help him with attaining supplemental medical? So this has been a question, is what is our obligation where an employee maybe doesn't have their medical and the workers' comp case is not going anymore, or they've got medical in the workers' comp case that isn't applicable to the CalPERS disability retirement. So maybe we're dealing with a presumption in the workers' comp that's not directly applicable in CalPERS. Then the issue becomes, well, maybe we don't have to help the employee because it's their application. So if they can't carry their burden, then do we just deny the application? So that's it, and then they could appeal. And so that's just a decision you'd have to make. And okay, so someone's mentioning that Government Code Section 21156 says that we shall immediately retire somebody where the evidence shows that they're subject to disability retirement. And they're kind of pointing out that it seems contrary to the sick leave and the Labor Code 4850 provision. And I think that's accurate, but I guess the way they've been read together is that it's subject to that right. So we have to act, I guess, at some point, but we're subject to that right to run out those leaves before it becomes effective. Okay, so moving on, so we're going to talk about the new requirements. So kind of a good segue into our newer requirements. So we talked about the certification that's always been there. And I'll talk about some of the forms too as we go through. And some of this is kind of new and still evolving. I'll just tell you kind of anecdotally what I'm seeing and some of the conversations I've seen, heard or reviewed. So we have the physical requirements of occupation, position, occupational title. So this is a new form where, since before we were just doing the certification, CalPERS didn't really ask about their duties specifically. We just certified that they couldn't perform their usual and customary duties. So now they actually want us to fill out something more like we used to fill out for miscellaneous employees, where we have kind of the amount of time, physical requirements, that kind of stuff. We have to provide them with a job duty statement. So, your classification for police officer, firefighter, whatever it is. Physicians report on disability for local safety. This is new, and this has been the big one, the kind of the big issue. And you can see why CalPERS is doing this, and I'll talk about it. The workers' compensation carrier request form, so we're requesting information from the carrier, and all reports used in making the decision. And finally, the determination, resolution, or certification, and that is the component we talked about just a few minutes ago that was always required. So basically, these I'm going back a slide, these 5 bullet points are now required. Before it was just really this last bullet point. And we were just certifying kind of all this other information. So the physical requirements of position, occupational title, we did used to kind of have to fill something out like this when we filed miscellaneous applications. If you ever filed a miscellaneous application, because with our miscellaneous employees, CalPERS actually makes the decision on whether or not they're qualified for a disability retirement. And so, you can, if you look at the circular letter, it'll hyperlink to this form, but basically you indicate how often the member performs certain duties, things like that. Usual numbers of hours spent doing the duties. So you probably fill these out. It's supposed to be filled out in like kind of a cooperative process with the employee. So both of us are supposed to sign it. All right, the next one is the physician's report on disability. And this is new. This is the big one. And I think I understand why CalPERS wants this. So in workers' comp, and I have a slide on this a little bit later, but I'll probably just mostly either foreshadow or kind of jump the gun. So basically, in workers' comp, there's a lot of things that are very different. So first of all, the amount of money at stake can be very different. The benefits that workers' comp provides is more modest. I think that kind of tends to lower down the standard. The other big one is that in workers' comp, you'll see what's called prophylactic work restrictions. Sometimes they won't be called out as prophylactic work restrictions, but that's built into the system. And so if you do a lot of workers' comp stuff, you'll see things like no push, pull, lift 5 pounds. And you're not going to see these people waiting outside of a mall door waiting for somebody to open it because they can't pull 5 pounds. It's not really a restriction. It's a prophylactic, meaning maybe this causes some pain, or maybe it's going to lead to further injury if they keep doing that. And so we're just going to tell them, don't do that, kind of, ow, it hurts. Okay, don't do that. But that's not the standard in CalPERS for a public employee's retirement, under the public employee's retirement law for a disability retirement. It has to be an actual present inability to perform the function. There's case law that says pain or difficulty in performing it is insufficient. And so I think what CalPERS was trying to do is decouple itself from workers' comp and affirmatively say, don't rely on just what the QME is saying for restrictions. And which frankly is what probably most agencies were doing. As I'd say I would be comfortable saying a strong majority, and we're probably still doing that. The other thing is presumptions don't apply under the public employees retirement law. So you're not supposed to have like the cancer presumption doesn't apply. So you can have a split where in the workers' comp case, it is industrial, and in the public employees retirement law, under the public employees retirement law in CalPERS land, it is not industrial. So they're kind of trying to get away from that. And so they want you to ask the specific questions related to CalPERS. And so they're trying to have these exact questions called out to make sure that the individual meets the actual CalPERS standard. That's not just, spillover from workers' comp. I think one of the growing pains I've seen on this, or some of the problems we've seen, is that a lot of times QMEs don't want to fill this out because it's not a workers' comp form and it's not a workers' comp proceeding. And so it's really outside of the scope. I've seen some workarounds where, workers' comp attorneys will jointly ask that it be filled out by the QME or somebody else. Another issue that we've kind of seen is it's like employees are kind of actually trying to push the process forward themselves. So they have their PTP fill this form out, they turn it into the employer and they say, here's my form, please grant me my IDR now. And then the question becomes, well, do we really want to rely on the PTP to go ahead and grant this? Maybe we don't even have work restrictions from the QME, maybe the restrictions don't seem realistic. And so that's been kind of one of the issues we've seen. So there has been some difficulty in having individuals actually fill out this form. Somebody asked, what was the date of onset for the additional requirements? I think the circular letter was issued it was like the middle of May. I want to say May 15th, May 17th, somewhere around there. Are originals needed for physician's form? I have a QME who only sent the signed PDF form. The doctor, so I think that copies of reports should be fine. I know there's been a lot of back and forth with CalPERS about original signatures and DocuSign signatures. But I think for the most part, they've accepted copies of medical. I don't think that's been a problem. I'll actually defer that question until the end. Okay, so moving forward to the next form, we have the workers' compensation carrier request form. So we now have to send a form to the workers' compensation carrier. We fill out sections 1 and 2. You're supposed to send it off to your workers' comp carrier. They fill out the rest. Generally, we're supposed to get the medical reports back. The actual form is more inclusive. It says all sorts of things, like all of the medical reports. I mean, generally, the medical files can be huge. Usually, what we're relying on is the med legal type stuff. But it does reference depositions and things like that. It also asks them for information about whether it's accepted, where they are on settlement, their investigation, things like that. For the most part, I think this is for the benefit of the local agency. I haven't seen any requirements where you actually have to supply everything you get from workers' comp to CalPERS. A lot of times agencies don't actually get this much information when they certify the decision, or they at least weren't. I mean, theoretically, I guess if you're doing your due diligence, you should ask for access to pretty much all of the information to make sure that it actually qualifies. And you'd want to know about things like, are there severosa problems? But a lot of that is summarized by workers' comp. But that is something like when we're challenging IDRs or we're determining whether to get an IME, we would review things like their depositions. We would be providing those to our IME doctors. And so you have to sometimes get that entire file. So once an agency makes a determination regarding the member's disability retirement or industrial disability retirement status, it has to basically send that information in those forms to CalPERS. So we're going to send the determination resolution or letter. So that's the actual certification. We're going to send the physical requirements form. So what are their job duties, or their usual job duties, et cetera. The job duty statement, the physician's report on disability. So that's, again, that form. And we're supposed to attach the medical opinions that we're relying upon, and the workers' compensation carrier request form. And again, the medical reports that we've used to support our determination on the disability retirement. Okay, so somebody's saying that CalPERS pushed back on the signed PDF, and we needed the physician report and AME report to have it DocuSign. So that may be something they're kind of pushing now. Most of what we submitted doesn't have that. A lot of times they're not. They haven't been DocuSigned, so that's something that we'll probably have to kind of work through. And I will say generally that's kind of one of the problems we're seeing right now, is that CalPERS really didn't proceed by regulation. We've got a circular letter, they've got their forms, but the unit is making a lot of informal determinations, quite frankly, by email. And a lot of them aren't grounded in anything that's published. And I think that's caused a lot of kind of consternation, because it's one thing to like create a bunch of hoops to jump through and they're there. It's another thing where, you know, it's kind of like you're dealing with a Kafka novel. You have no idea what's going on over there and you're just trying to comply, but you can't figure out what's going on. And I think there's been some of that. It's kind of been some of the frustration with the process, is that there's requirements, but they're not sure about them. And I know that I guess the signature thing is important, because during the CalPERS webinar, they spent kind of an inordinate amount of time talking about the signature requirement, who had to sign, what was required, no fours, that kind of stuff. All right. So independent medical exams are kind of something that's interesting. So the government code allows the CalPERS, and by delegation, the governing body, to send somebody for an independent medical examination when there's really kind of maybe you have a question out the medical. Now, these weren't really that common. A lot of agencies were relying on workers' compensation to just kind of, if they got something from the workers' comp doctor that says return to work is not recommended, then they would just go ahead and rely on that to certify the IDR. And, you know, I think CalPERS is trying to get away from that. And I think you see why they're trying to get away from that. They're trying to decouple themselves from workers' comp. It's a different standard. It's, you know, it's set up for different purposes. You know, CalPERS takes care of the injured work. I mean, workers' comp is really supposed to be taking care of the injured worker. There only in some cases do you get permanent disability, and only some cases do you get a pension due to the disability. And I think they're trying to say, look, that's different than the benefit we're offering in this arena. So, you know, difficulty, pain, not wanting to go back to work, those kind of things do not qualify you for a disability retirement in our arena, and we don't want you relying on them. So you could always retain an IME, and basically I used to kind of almost do the local physicians form, where I would send the IME a letter that says, here is what the CalPERS standard is. Please answer these specific questions. And I'd actually modified that from CalPERS' own kinds of when they had sent their IME letters. And that's kind of what I had used, because again, the standard is different. So now we're looking at, our agency is going to have to get more IME, are we going to have to schedule more IMEs to push these through? And that's kind of led to a few interesting questions, because CalPERS is kind of, what's been happening is agencies are sending in their certification documents, and CalPERS has been holding things and saying, you know, I've seen some where they're like, well, this person has an orthopedic injury and they're seeing a pain management specialist, so no good. And then they're kind of just holding the application and telling us to fix it. And the other one I've seen, as I mentioned, is the PhD QME rather than the MD QME. And so then CalPERS is holding the application, and they're not really releasing it, and they're telling us we need to provide them additional information. And that's where, when I talked about the discipline part, where I said that CalPERS kind of you know, formalized their process for when they're blocking an application, and I thought that was good. I think we're not there yet here. So what's happening is they're holding the application, but they're not giving anybody due process. They're not doing a formal rejection. It's just being held, and they're asking us through email for information that complies with their request, which then again, there's not really much published guidance on. And so I think that's been one of the issues. And in a lot of those cases, they're telling employers, well, you're going to need to send the employee for an IME. And that raises questions about, well, do we really have to send the employee for an IME? It's not our application. So if it's insufficient, then either, you know, and you're the one blocking it, then shouldn't you give them due process and an appeal, because they are entitled to an appeal? And if you're saying it's insufficient, then I guess you could return it to us, and we could then deny it as insufficient, and then maybe we'd have to run the appeal. But it's been problematic that it looks like it's just being kind of held while there's additional information. And so that's something, what I'm hoping is this kind of process plays out and we get more formal guidance, that's something that there's more of a structured process involved. Okay, someone's asked, are employees entitled to full medical reports, which we need to send to CalPERS now? Some workers' comp attorneys believe agencies are only entitled to excerpts related redacted medical reports. This is another problem. So under the labor code for workers' comp, basically employers aren't supposed to get chapter and verse of what's wrong with an employee generally. So they might go through something where they're talking about their doctor goes through their social history with them, sexual dysfunction, all sorts of things that really aren't relevant generally to the employer about whether or not they can be accommodated at work. So really the labor code limits it to certain things for cost purposes, and then there are limitations for the purposes of engaging in the interactive process, essentially. And that's really generally all an employer's entitled to. Now, here though, the employee has filed an application and we are the delegate that has to make a decision on that application, which makes us distinguishable from those general situations under the labor code. Now, how you get this medical evidence kind of depends on the workers' comp administrator, where you are in the process about who can share what information. Like you have two attorneys where that's maybe okay. Now, when the individual files an application, they do sign a waiver. And I have presented that to a number of workers' comp attorneys who have basically said that, or carriers or attorneys who have said they will accept that waiver, that we're the delegate, and they will provide us the medical file. And I've sent that in the request for medical files where we have a pending application. And I've explained that we're the delegate, we have a waiver in place. I have had some workers' comp attorneys and administrators who will not accept that waiver because it's not clear that it's in favor of the public agency and it doesn't have some of the stuff it probably should have in it. So I have a point on that, whereas sometimes we might have to get a HIPAA waiver or something like that, or a CMIA waiver from the employee to release their medical information, and they should be cooperating in that process because otherwise we're not able to process their application. So if they wouldn't provide that, we may have to take that up with either CalPERS or explain to them that we can't process the application without reviewing that information. But yes, we are entitled to the medical evidence because we make the decision, but you might have to jump through some hoops to get it. And that might include, providing the waiver or getting a special waiver from the employee. Somebody asked, safety employee that is not MMI and is terminated for cause, would it be responsibility of the safety employee to apply for service retirement pending IDR? So discipline does not cut off your right to a service retirement. Generally, there are some forfeiture statutes that are new where you engage in work-related misconduct. Generally, though, you can still get fired for cause and apply for a service retirement. The disability retirement, if they apply, then that triggers the process where we would have to notify CalPERS, and CalPERS would have to decide whether they're going to block the application and then let the member appeal that decision. And when CalPERS blocks the decision or the application in the context of discipline, CalPERS does provide the appeal to the individual. So they give notice to the employee that their application is not being accepted, and the employee gets to appeal that decision, and CalPERS has to set up an admin hearing for them. Okay, so I'm going to answer this question real quick, but it's kind of long, so just give me 1 second. Okay, so somebody has a question where they're saying that where there's some kind of deviation between the disabling position or disabling body part mentioned in one of the medical reports, like a PNS report or an MMI report, or it has an additional body part in there that's not in the CalPERS physician's report on disability. CalPERS is kind of considering them a mismatch and holding the application up. And they're kind of pointing out that, well, if one is sufficient, does it have to be a match? I think you could argue it both ways, because on the one hand, the applicant, it does mean that they're actually qualified for it. I guess the issue CalPERS is concerned with, and I have a slide on that a little bit later, is that they have to look at whether the person can be reinstated from employment or whether they can have other employment. Can they work a different job? Is this job something that's within their restrictions? And if we're going to reevaluate them, we can only reevaluate them on the body part for which they were disability retired. So that's going to be CalPERS's position. So how that's going to play out, that's one of the things where I'm saying there's not really a great conflict resolution process for when this is happening. And a lot of it's happening, frankly, ad hoc by email. Okay. All right. So talked about independent medical exams. I mentioned that IMEs may be needed more frequently. Again, CalPERS is trying to decouple itself from workers' comp. And we do do IMEs sometimes. I think we're probably going to start seeing more of them because a lot of times the workers' comp restrictions are prophylactic. For example, you will see very few people that are kind of returned over their objection in the safety context from workers' comp. So you'll see sometimes where the employee will say they don't feel safe doing something, and workers' comp will give them that restriction not to do it because of that. That is a prophylactic restriction. CalPERS' kind of point is that doesn't entitle you for an IDR. You need to send them to an IME to determine that. That being said, there's not necessarily a legal requirement to send somebody to an IME as long as you have enough information to meet the CalPERS standard. So it's not necessarily required in all cases, but there may be instances where we will have to get an IME. And then I also mentioned that we kind of have this ongoing, I guess, a little bit of a conflict about whether or not, it's really the agency's obligation to set somebody for an IME, because if they don't have a sufficient medical according to CalPERS, then it just means that their application could be denied. But of course, then we have to deal with the appeal. So that's something you have to work through on a case-by-case basis. All right. So to do the IME, this is mentioning the waiver. We do generally try to get a waiver, or sometimes we'll use the CalPERS waiver if they transfer it to us, because we do need to get a hold of the medical file, because we do need to provide it to the doctor in order for the IME doctor to know what's going on. Otherwise, they really can't. They don't see the MRIs. Like, they really need, and a lot of times they will need more than the QME report. They will need other underlying documents, because that's where they're going to base their opinion. They might be looking at MRIs, things like that. So when we do this, we generally send I used to send a letter to the physician. It's still what I do. But now we might have to look at whether or not we have to use the specific form. I have concerns about whether the way things are going, whether CalPERS would even accept they should, because it's the same question, but will they accept this, the written report from the doctor that answers the question, or are they like, no, we're using the TPS report from now on. And then they send you the circular letter again, even though you've seen it. We have to authorize the physician to conduct the disability evaluation. We ask the physician to answer the specific question. Now we might want to give them the form. There is obviously we have to pay for the IME in this context. It's on our dime. And if we have them travel more than a certain distance, and then there's an end distance too, then we have to pay essentially for their travel. Somebody asked about the fact that I mentioned that the labor code presumptions don't apply. And with respect to cancer, then yes. So CalPERS would say that if someone gets cancer, it has to be deemed industrial under the CalPERS standard in order to qualify. And so again, I am jumping ahead, but if like an example that's kind of easy, and none of these are good, obviously, but if somebody has colon cancer, we don't really medically know very well what causes colon cancer. So most of the time, under the workers' comp system, the employer accepts it as a presumptive industrial injury because of the cancer presumption. But then when the shoe's on the other foot under CalPERS, then we don't really know that there's nothing about being a police officer or a firefighter that would cause you to get colon cancer. And so they probably can't prove that it's industrial. And so you will see a split where it is an industrial injury for the purposes of workers' comp. It is not an industrial injury for the purposes of an industrial disability retirement. So you will see a split of causation in those cases. Industrial causation does go to the WCAB, which is kind of bizarre. So if it's incapacitation, it goes to, we have to have the hearing with Office of Administrative Hearings typically, or an ALJ who issues a proposed decision to the entity. If it's the industrial causation that's at issue, interestingly, it goes to the Workers' Compensation Appeals Board for adjudication. But based on a couple cases, one being Pearl, P-E-A-R-L, even though it would be a great pun, Pearl v. WCAB, this California Supreme Court said that while we're applying workers' comp substantive law, we are applying while we are applying workers' comp procedural law, we are applying CalPERS substantive law, meaning the underlying actual body of law for the decision. Okay, so if you're going to use an IME, you need to make sure you're using an IME who kind of knows the standard. You probably want to pick somebody who's done these before. Sometimes agencies try to use posts like they do for their pre-employment. I don't know that that's a great idea, because it's kind of a whole, it's not the same kind of thing. And a lot of times they don't do those type of disability retirements. They're usually determining at the front end whether this person should even get in the door, not whether they should be out the door and entitled to that kind of a benefit. But you do want to make sure they're medically qualified. I guess, especially given CalPERS recent guidance, you want to make sure that they are in the same specialty. Typically, you want to retain somebody who's actually done these before, or at least can do them. But you want somebody who understands the actual standard. I'm going to defer questions because I think we've had a lot, and I'm going to make sure I get through them, but I will get to them at the end. And as long as we're okay to, I can stay on a few minutes too. So I've already kind of foreshadowed the workers' comp versus IDR pretty well. So big thing, labor code presumptions do not apply. Again, the cancer example, the heart presumption doesn't apply, a bunch of things like that. Duty belt presumption. Industrial causation for the purposes of CalPERS must be real and measurable. That standard is not real and measurable, but that's what we've got. It would be better if they gave us, something we could use that was actually, we could use a percentage or something like that, like workers' comp does, but it just says real and measurable. It can't be inconsequential. It's mostly developed through case law. And it must be based on competent medical evidence. I've already gone over kind of some of the issues on that. CalPERS, really defining competent medical evidence is something where CalPERS probably should proceed by regulation and actually interpret the statute formally, or at least have a circular letter that really kind of lays it out. Maybe I've missed it in something, but I haven't, I know they read it. It seemed like they read a definition at the webinar, but I've never seen that written anywhere. As far as some of the requirements they've had and some of the reports we've gotten kicked back based on what we're being told is the definition of competent medical evidence. I think they're kind of a little bit operating, maybe they kind of probably need to put that into some kind of more formalized guidance. And I think, there's some of the stuff that even if we disagree with it, we can deal with it. They want the DocuSign, fine. They want Calibrate instead of Times, fine. Whatever. There's stuff like that I think as long as we know at the front end, we can deal with it. But it's right now, I think they're still firming things up. And that's where I think some of you, and I'm seeing from the kind of questions, some of these are being held up and we're not really sure why, or we didn't understand that to be a requirement. I talked about incapacity must be based on present and actual disability. So again, this is huge. No prophylactic work restrictions. And if you look at a lot of workers' comp restrictions, you will know you know that a lot of them are prophylactic. You'll see a lot of no push pull, 5, 10 pounds, 15 pounds, and you know that person can physically do that. A lot of that stuff would actually start to go into inability of self-care. And so that's one of the things we kind of look at is that's not necessarily those are probably not actual present disabilities. Just a couple hypos. We won't go too much into detail, but just kind of as an example, police officer Jim suffers a work-related injury related to his knee. He goes on a medical leave and files for workers' comp. His workers' comp doctor states that he should avoid running and walking on stairs to avoid further injury to his knee. Jim then files an application for IDR. Is he qualified? And what we'd be looking at here is this a present disability or is this a prospective or disability or prophylactic restriction? And this does smack of a prophylactic or prospective restriction rather than a present one. So that's what we'd be looking at. A similar variation would be his workers' compensation doctor states that he should avoid running and walking on stairs to avoid further pain or discomfort. And there's case law that says that essentially, for the purpose of an IDR, the fact that you have difficulty or discomfort isn't enough. You would have to be physically incapable. Talked about the duration. So disability duration permanent or last at least 12 consecutive months. From the date of application is what CalPERS says in their guidance. The statute doesn't actually specify from the date of the application. And CalPERS also wants continuous disability from 1 year before the date of last physical work to present. That's another one where I'm not really sure about that. You could think of situations where we don't really have to wait it out. Like if somebody was rendered a paraplegic, we might be waiting that out anyway because of the workers' comp and their sick leave and stuff, but it seems odd to say that would be an actual requirement to disability retire them if we basically had a situation where, it was pretty clear that was permanent. Okay, so a lot of it, I've talked about case law development. So another interesting thing is the job duties. So it has to be the individual's usual and customary duties unless it's integral to the position. So, for example, we get this to come up a lot in command positions. So you have a chief who applies, a captain who applies for industrial disability retirement, and they kind of say, well, yeah, I'm the chief, but I might have to be out there, or if I'm out there and I see something, I've got to do something, and therefore I have to be able to physically apprehend suspects. And if I have, a back injury or something like that, then I'm entitled to a disability retirement. And under CalPERS standard, the answer is probably no. because as the chief, if their usual duty is to be an administrative person, they don't go on patrol, they don't do anything like that. Even if it has happened before, or it was kind of something that could theoretically happen based on a series of events, that is not a usual duty. And so it's not supposed to be the most, you don't really try to come up with like a scenario where this could happen or, whatever. We're looking at what is their usual duties. There are some exceptions where they're actually required to perform all of the duties, and if that's a minimum qualification. But for the most part, those command positions are going to be ones that you might take a position that's not a usual duty. In Mansberger, it was I think a game warden or something like that. And in some cases, they would have to drag carcasses, but it happened very infrequently that they would have to drag very heavy carcasses. And so that was not a usual duty. He was not entitled to a disciplinary retirement. To determine usual duties, we don't just look at the job description, we look at what they're actually performing. So what do they actually do on a day-to-day basis? And then there's some cases, as I mentioned, that talk about the fact that discomfort or pain is not generally sufficient. It has to be inability to perform. Okay, another hypo. Sergeant Dan injured his back in several incidents. He experienced continuing pain and believed he was in danger of further injury when he had to overpower people who resisted. Although strenuous activities such as apprehending fleeing suspects was a listed job duty for his position, he rarely performed that duty and could physically do it if necessary. Sergeant Dan is now filed for IDR. What is the result? So we have two different ones here. One is it's not a usual duty. So a lot of these cases involved like sergeants in larger organizations that were kind of quasi command staff. And then it was like, even when they are out, they might have some difficulty or some pain, but it's not that they physically cannot do it. And so again, just kind of distinguish, kind of pointing out that case law. So competent medical opinion, we've kind of foreshadowed this a lot. So the local physician form says that it has to be by a specialist. That's the only place I've seen that actually written is on that form. It's not in the statute as far as we can tell. I don't think it was a requirement. I mean, we never got anything kicked on that basis pre-March 2023. So it does appear to be some kind of new requirement that they're inserting. It has caused some problems because a lot of the workers' comp QMEs who are picked may be pain management specialists or PTPs or pain management specialists. And I've seen CalPERS kicking some of those. I already mentioned there's been a couple of orthopedics, and they've also, as I mentioned, the MD requirement. And those aren't, again, haven't seen a lot of formalization on that realm, but we'll see. For work restrictions, the work restrictions must directly relate to the disabling condition. That might be what that individual's question was about CalPERS being concerned about the mismatch. And I think that has to do with CalPERS saying, well, if we have to reevaluate or you have to reevaluate, then we need to know what body part they were disability retired on. So why is CalPERS requesting the new information? I mean, we don't technically know. They've provided their rationale that the requirements are essentially for them to determine whether the employee actually meets the standard, and whether the member is actually entitled to benefits. And I think this is where we're going to see, well, I'll actually move to the next slide. So how will CalPERS use the new information? I think this is what a lot of us have been wondering and kind of seeing it play out a little bit, because the statute is very clear that the agency makes the determination on whether an employee is substantially incapacitated from the performance of their usual duties. And CalPERS is kind of encroaching a little bit and they're saying, well, we administer the PERL. We need to make sure that you're granting benefits appropriately, that they comply with the PERL, that the entitlement is proper, that kind of thing. And so what we're seeing is kind of this tug of war where agencies might be saying, well, hey, this is our decision to make. Why are you telling us no? And CalPERS is saying, well, we are the gatekeeper who makes sure that they're actually entitled to benefits. You're still making the decision. And so I think that we're going to see some tug of war, some playing out of how that different relationship is going to go. But there definitely does seem to be some kind of substantive review going on. I mean, we are getting medical reports kicked back. And so we'll just kind of have to see how that plays out over time. So again, yeah, one of the big issues I think is, again, that they're concerned about that too much of this is flowing from workers' comp. And you know, that may in fact be the case. There's a lot of times where there's kind of just me too the workers' comp case, even when, you know, maybe we really are dealing with prophylactics and things like that. Okay, so I've got a couple questions and a couple minutes, so I'm going to take these now. So is the CalPERS authorization to disclose protected health information sufficient? Especially if the employee designates the IME on the form. So generally, we have used that as the basis for disclosure. I mean, the employee files the application, they are signing the waiver, CalPERS provides it to us. So I think that there is an argument that is sufficient. I have had some workers' comp carriers and workers' comp attorneys who will not accept that waiver. In some of those cases, I've prepared a CMIA waiver and provided it to the employee, requesting that they disclose their records. And arguably, if the employee didn't provide them, then I think that would be grounds to request that their application be denied or canceled, even because they're not cooperating. As far as designating the IME, well, generally the IME, although it's called an independent medical examiner, it's really usually the entity. In the context that I'm talking about today, it is the doctor retained by the agency to do an evaluation for the purposes of the CalPERS disability retirement. There are some other instances in workers' comp where somebody's called an IME, but it's not the same as I've been talking about them in this presentation. Like, for example, in some of the workers' comp carve-outs, there's an IME process. So what happens if workers' comp says safety can't work, but PERS denies the IDR? This is a very difficult and somewhat open question. So again, we have workers' comp restrictions that can be prophylactic. We have CalPERS restrictions that are CalPERS entitlement that says the restrictions can't be prophylactic. And so what you end up in is this kind of standoff. And so there's as far as I'm aware, it hasn't been definitively settled by courts, but one argument is that they're different. And maybe if they want to rely on their workers' comp restrictions, they're not eligible. If they, it's just a different standard. You may not be, workers' comp may deem you ineligible to work, but you don't rise to the standard of a CalPERS industrial disability retirement. There's some case law that says you can't deny them both, because that's, would be unfair. You can't say on the one hand they're not working, on the other hand they're not disabled. The one court that had to deal with this kind of split and said, well, if it's denied, then it just means it's a temporary disability and we keep engaging in the interactive process. But there is not a whole lot of case law on that point, but the standards are technically different. Somebody's asking me, do you foresee CalPERS taking over the safety IDR process? I don't know. So for now, they have it for miscellaneous. I can imagine that some of the people on this webinar would be more than happy to have CalPERS just take it away. They file their application, we tell them good luck, and if they remain employed, they remain employed. If they don't, they don't. Right now, the statute still says the local agency makes the decision, and that statute would have to be amended to actually change that process for CalPERS to just handle them like they do miscellaneous. There's probably a lot of, politics that would go into that. I would imagine that on the labor side, they probably would not want CalPERS to take it over. And you might see a lot of pushback there. I don't really know. I don't know how CalPERS feels about taking it over. But it has been a question that comes up from time to time is CalPERS just going to take this over? But who knows? We'll see. CalPERS has indicated, somebody's saying that they talked to CalPERS about the benefit. They're saying we're not denying it. They're just saying it could, it's delaying the process, and they're trying to ensure that they're entitled to the benefit. And that's where I'm saying we're going to get this tug of war about, well, are you blocking the application and this member should be able to appeal? Are you returning the application to us? What's going on? And I think that's the process that hasn't really been firmed up yet. And I mentioned, we, kind of trying to go by analogy of where this might be going. We saw in the context of discipline that they did kind of firm up a process. They decided they were the gatekeeper, and if they blocked it, they were going to provide an appeal. And maybe we'll see something like that. Maybe they'll have a process for rejecting it and returning it to the agency, and then the agency has to deal with the employee, whether they're going to be, because somebody has to provide due process. I mean, if we're saying the application is no good, then at some point it has to be released, and somebody has to get the employee has to get their appeal right, or something has to happen. It can't just be put in limbo. This is definitely something where due process is absolutely required. So we'll kind of see how that develops. So somebody says that on the webinar, they didn't see that there was a significant amount of time on presumptions. Somebody asked, is this thing on presumptions in their circular letter? And it is. And I actually have a circular letter on my desk, which is, I guess, speaks to the state of my life. I also have a Pearl back there. So it is. It's in the 2017 circular letter. It mentions that there's no presumption, or the presumptions don't apply, I believe. And then we have the Pearl v. WCAB case says that it is CalPERS law, substantive law that applies. Will an employee's retirement payment be held up with an IDR pending retirement with this new process? Yes, they won't get the allowance if their application is being held, and you might be still paying ADPP too. So you're actually paying out the advances maybe while the application is being processed. So that's why we're trying to work through these. And I think that is it. Okay, and I am exactly on time. So I'll turn it back over to Leanne for any closing remarks. Other than that, thank you for attending.
Just a big thank you, Michael, for your time today and presenting this timely information. I know a lot of us have questions in this area, and this really covered everything in totality. So much appreciated for your time today. To everyone else, thank you for participating today. Again, we will be sending out by email the recording and the slides, so you'll have those to reference at a later time when you need them. And again, please take the time to join the Personnel and Employee Relations Department and participate with the group. It's really a great experience, and there's a lot of information that gets shared that helps us all do our jobs. So thank you for attending, and enjoy the rest of your afternoon. Bye-bye.